there are very substantive issues of law which are involved. Obviously, all this is without prejudice to that. This, at the best, what is being suggested is administrative tweaking where necessary in a committee based on suggestions. Legal tweaking is another system. The laws are involved in many places. So what we'll do is we'll confer. Without prejudice, we can certainly give. But personally, when I don't think that your lordship will have any major solution, having seen the gamut of problems and the level at which conceptually and jurisprudentially matter has been argued, I think it is better that you should spend so much time to go on to a decision. But we will certainly give this. This can be an addition. Anything tweaked administratively and helping is always a help.
Because I think, sorry, Dr. Singhvi, look at it as a one or none. Because although he's saying administrative, there are substantive issues here. When you're looking at insurance, your housing, etc., these are as substantial in terms of the benefits that people can expect. That is actually the practical way out. What are the barriers which you're facing? That those barriers you should give it. If there is a frank discussion out of that, although this is being termed as administrative, this will have to translate into some changes in the regulations, maybe even law. So to what extent they are willing, to what extent...
Certainly, but the word administrative I said was that many of them will require substantive changes to law, which I don't think is what my learned friend is saying. What he's suggesting is that a circular may be changed. Office order may be changed. I may be wrong.
No, I'm just expressing
without thinking of what do I learn.
Whichever mode, method or manner in which that problem, if permissible, can be addressed, that's there is no existing rule which
let's come down to some example. I think Dr. Guruswamy made that chart containing of, or even you had presented a chart of the seven items. Some of those don't require substantive.
So therefore,
now sometimes beginnings are small.
No, certainly.
Those beginnings could be very substantial in that sense.
I bow down. Beginnings are small is absolutely opposite, but whatever little is given by administrative tweaking, certainly it would be welcome. I'm only saying, that this should be seen as a constructive effort towards a convergence. It may not, be a substitute for the larger. That's all that I'm saying.
But Dr. Singhvi, one step at a time, while the matter is on.
Yes. Immediately, I started by saying that. We will
do it. Maybe if there is any statutory tweaking required, depending on the kind of needs that have been highlighted by.
Yes.
Be open to look.
What we are right now aware of what we are dealing with. Suppose there, as my lords very rightly pointed out, that it might need change of law, and change of law might need some wider issues of recognition of a particular relationship. Then we will have to examine whether that can be done.
Therefore, also, Dr. Singhvi, the way we are looking at it is that from the drift of the submissions which were made by the learned solicitor on the last occasion, it appears that the solicitor also accepts that, of course, people do have a right to cohabit, and the right to cohabit itself is something which is now an accepted social reality, at least. Based on that, there may be certain incidents of that cohabitation. For instance, in relation to your right to reside together. Second, bank accounts.
Insurance
policy.
Provident.
These are practical issues which can be resolved by the government. From your perspective also, this is a step forward.
Absolutely.
You see,
for example,
therefore said you don't have to go for all or nothing approach.
For example, two persons, an old man, are staying together. They are not necessarily in any gay relationship. For companionship, for looking after each other, etc.
That analogy misses the point. It does not take an assertion of rights for two adults who are self-sufficient to live together. That is an exercise of free will. Rights is a proactive, positive enactment that the law recognizes. There is a distinction here. So an old man being taken care of by a caregiver misses the point.
No, but that's not caregiver. Two people, three people staying together, they want to share their bank accounts, their insurance.
We are talking specifically of same-sex relationship.
A caregiver taking care of a person under his care, or a relationship where you're claiming these rights. practical effect would be that the
You're
caregiver,
cohabiting.
let's say the person who is the one who is being cared, he is neglected by his sons, he is neglected by his children or other relatives. He does not want to give it to them. Now, short of creating a will, in case he dies intestate, if he has a nomination, he cannot nominate this. See, today
Be a part of, say, medical insurance. He wants to be a part of medical insurance.
But may I just say this, for something as simple as pension, provident fund, gratuity, benefits, that accrues only in a marriage. It does not accrue to the caregiver. What accrues to the caregiver, even in other systems?
that's the reason why one is putting forward this idea.
Yes, my lord.
And that accrues in a marriage because of the nature of our rules.
Correct.
If you have to, therefore, that's something exactly which the government has to consider. And that's why we thought.
Suppose hypothetically, I do not know, my lord, what will be the implication. My lord, suppose the government says that nomination in case of provident fund would be a family member or anyone else which the retiring person chooses to. No, then you don't need to go into anything else, my lord. The problem is solved.
Let us be clear. Just
Sometimes solutions are, my lord, simpler than the problems.
To be clear, when Justice Paul is saying.
One second, Justice Paul wants to say something.
Dr. Singhvi, please notice, as my brother colleague said, this is without prejudice to everybody's rights and contention. One. Number two, even if the court was to, suppose you were to succeed to a limited extent and the court was inclined to give you a status of a marriage or inclined to give you a status of some other status, let us say not marriage, but some other status. There will be many changes required in administrative proceedings as also legislative aspects. Therefore, if there is a consensus, at least whatever be the status recognized, after all, they are not denying that this is an incidence of society which is happening. They are reluctant to give it a status of marriage. But they are not, I believe from what solicitor says, reluctant to sort out the problems arising from a gay companionship without labeling it as marriage to the extent possible. Now,
may I respond just 1 second?
Not gay, but there are several combinations I don't wish to go into.
Mr. Solicitor, let the
It becomes unmanageable, my lord, to fathom.
let me
Multiple combinations, my lord, which can arise.
Let
me complete, Dr. Singhvi. Let me complete. Yes. Therefore, what is the suggestion from the bench is that the nitty-gritties of what may in any case be required to be done in either situations, some endeavor or step is taken in that direction. I think that's what Justice Bhatt and the Chief Justice put. So I think let us, without prejudice to anything else,
absolutely
not sit with pre-notions or prejudice notions on either side as to what can be sorted.
I start with that.
To both the contentions.
Solicitor, 1 minute, please. Whereas I start with that, give me just 2 minutes. Your Lordship may take it. I started with that. And I'll do better, Wallace. I'll try and make a chart which is actually 3 categories.
Right.
And a 4th is, Wallace, conceptual. Give me just 1 minute. One category clearly, possibly solvable immediately is the so-called administrative tweaking, which is followed from my Lord Justice Bhatt, Justice Call just now. Surely what you can get by easy tweaking, there is no question of looking a gift horse in the mouth for no reason at all, just because we are on some principle. Of course it should be cooperating, of course we'll give that. A second category may be something more than that. A third category may be substantive, bigger changes. I'll try and identify them separately. But above all these 3, so the first category, Lordship will take it, people will meet up, people will make a list, people will share it with the solicitor. We have no problem, we have no ego about it. The 4th idea is important for Lordships, and only your Lordships can decide it. That is the real, the symbolic, the actual meaning of marriage. That nobody can decide except this court, this way or that way. No committee, no circular, nothing can. Now that's the juristic question. 1 second, Mr. Solicitor, 1 second. That's the juristic question. Now, therefore, we are, as Justice Call said, we are happy to divide it, and what might be called low-hanging fruit.
Yeah.
Benefits everybody, everybody eats that fruit. Of course, we'll cooperate. The other fruit, will have to depend on some kind of an order. And we'll make that categorization to the best of our ability.
Equally, Dr. Singhvi, when we go into the conceptual domain,
yes,
we cannot be oblivious of the fact that to the extent to which the conceptual domain requires legislative changes, that part clearly lies outside the limit of the court.
That will be part of the dialectics.
Then the question which the court will have to face is, to what extent does the court go in formulating conceptual doctrine?
Yes.
Absolutely.
Because ultimately whatever doctrine the court formulates has to be relevant on the ground. All right? Therefore, there may be three levels really. There may be certain areas which are governed by pure administrative, changes.
That's what
which can easily be done by them. Second, changes which they accept as a matter of principle, which may require changes in some form of subordinate regulation. Which again is a matter for the government. They don't have to go to parliament for that. Which is again much easier to achieve than, say, a parliamentary change in legislation. The third is your wider.
Exactly. That's
your widest case, your fundamental point is that, well, there is a right to marry, one, with reference to constitutional precepts, even for same-sex couples. Second, that you can found that or source it in the Special Marriage Act.
It's not a hollow right, it's not just a shell.
That is what you have all argued. That is what you have all argued. That's something which we will have to ultimately decide, subject, and therefore that's what their argument is.
That's all that I'm saying.
That this is essentially a legislative arena, don't step into this.
Dr. Singhvi, yes.
Therefore, we are saying that, well, we will of course have to decide it. We are going to decide this entire issue as a matter of concept. But to the extent to which the government takes a first step forward, there would be a substantial benefit, a substantial advancement in the recognition of the cohabitational relationship of same-sex couples in the country today, which would be a substantial advance beyond what we have today.
Yes. I certainly have no such.
That's exactly the point. I would put it like this, somewhat like this, a bit differently, which is that Dr. Guruswamy and I think Mr. Kripal, all of you in different ways said that, this could be a part of a series.
Part of a
series, whatever you want. Look at it from the reverse. If this results in a gain, maybe not as substantial as you visualized, right? That's one of the building blocks for your future, No, do you want a ruling then? That too is something you may have to consider, given that you're now not really fighting a battle only for these petitioners, but there's a larger group of people who may not be covered by this dialectic of Special Marriage Act. So then, is it advisable or prudent, if you're going to get this, to continue with that larger push?
We'll build that into our
argument. Have to make that, take that call.
We'll reflect on that and build that into our argument. We fully understand what my lord is saying. Fully understand.
Can I say one thing?
Only one request I would make.
People who are not in that part of the dialectic. Because we've all gone and spoken in seminars, and there are people who believe in the absence of heteronormative institution of marriage. And when one goes out and meets 99% of the people who come up to you, they all say only one thing, that they want to get married.
Yes.
But the consensus within the community, no matter how many people may say that it is a concept that they otherwise reject, is that they wish to have marriage.
Yes.
Because this gives meaning, purpose, identity to the people who are seeking to get married. Because and my learned friend will agree with me. So it's not correct to say that there will be people who will be out of the bound of marriage, who don't want marriage, but they're happy with something else. I, personally, and I'm sure Ms. Guruswamy and Ms. Grover as well, in all the multiple meetings we've had, we hold some academic discussions of people who say, no, it's a heteronormative institution, it's not necessary. The vast majority of the young people I have spoken have all said, we want to get married. The parents of those young people have said, we want to get married. Because we say we want to get married. Why should we be second-class citizens? Because there was a time we were criminals, then we became third-class citizens. Now they're saying be second-class citizens, then be content. That is not what the Constitution promises.
Yes. So that's the third category. But I am not belittling your lordship's first or possibly second category. Please don't misunderstand that. All of us here, but we are all imploring your lordships to recognize a third category, incapable of partial minimal resolution by the Solicitor General. Incapable. But the first or the second, yes, we'll fully cooperate.
And one exercise we also undertake.
And we'll keep that point in mind, that whether we can give up something, not give up that part, I understand.
And ultimately...
No, in the sense, that it can be tailored.
You've given up anything.
No, for us, tailored.
My lord,
can I suggest also, we amongst ourselves, all the petitioners, are sitting down and we are trying to make some kind of a draft of what is it that we can hope to achieve. So there's a consensus in ourselves. We understand we can't get everything. Because we will put forward some idea of what is it that we hope that this court can give
That's
us.
exactly why we thought that some
Well,
sort of
that-
meeting of
that's
our
some
concept.
exchange of ideas between all of you would be helpful.
Consensus is amongst us already that at least Section 4 recognition of marriage has to be given. What rights follow from that, when, how, those modalities.
Yes.
So that is legislative. My lord, therefore, my lord, I would request.
May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, I make it a point to speak in small towns India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where there is marriage equality.
On the marriage.
Dr. Guruswamy, there's a problem with this line of argument.
No.
I'll tell you why. We understand the feelings out of which this argument comes. But at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by either popular morality or a segmental morality. We decide what the Constitution says.
But this is...
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us about what the country feels.
It's my only...
Let's not get into it at all.
My lords, this...
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You're also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in Section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure, by acting as a facilitator, that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize a right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation, or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this dialogue.
See, if you've seen the history, and in this side, you're all acutely aware of the history, you know better. You've seen the ups and downs of that for the last half century, and where it went to, what kind of legislation came, not positive, mostly negative, and how finally you got the judgment that the US Supreme Court gave. Now, you are circumventing all that. Of course, there is a lot of, let's say, feeling in this, a lot of felt, experiences in those. Nobody is discounting that. But if you do gain something out of this, that's a big positive. Because, I mean, there are so many processes outside of what we can speak in this country and in society generally, that these gains are also not to be belittled. Now, if you're likely to get it, I mean, just sit back and think what you're gaining.
Yes.
And then if you are still pushing ahead and you want that declaration, we will have to examine it. And even this closure or whatever, if this happens, I mean, this is completely, please let me complete. There is no closure. What I'm saying is, if there is some quietus to this at this stage, don't see this as the end of the battle, or whatever your movement is. Because ultimately, whatever your movement for equal recognition of equality of that would always remain. And even if these, whatever you get, the positive part of it, even if you don't accept this or partly accept this, now that too will not be the end for whatever you are going to do. One is speaking generally, not in any manner prejudging it.
My lords, in Obergefell and in America, the experience was that after Obergefell, when the Supreme Court gave its broad declaration, broad and firm declaration, the council for the parties then sat with the government, with the administration, and went through each law. And each department sat with them and they went through each law. I'm told it's 710 laws or something, and then sat down line by line and sorted out post the declaration in Obergefell.
But that was a different kind of, let's say, working out, because they had to work out what was unconstitutional. Oh, we are literally putting the alphabet together.
Yes.
That much harder.
But my lord,
And even Malhotra,
And not
there are good
not only
reasons in
mere
the
laws,
minority
there were
views also.
constitutions. There were constitutions which had to be invalidated.
but my lords, the only thing I will say
In
is that
fact,
we as
in Malhotra,
jurisdiction,
this judgment my learned friend is relying upon,
we as a
there were restrictive statutes which came before the Supreme Court.
but we as
Some states had
Now,
jurisdiction.
Mr. Solicitor, coming
My
back to
lord-
your submission, let's get on with that. In
that's
another
right.
10 minutes, we'll put
Yeah,
we'll put,
rejoinder.
we'll put the next
yes,
batsman in,
we'll do
and I believe the
Yeah,
next
Malhotra,
batsman will be learned batsman.
only one request Malhotra, to the other side. While giving the suggestions, Malhotra, I would request them not to give jurisprudential ideas, etc.
No, not at all.
Only-
That's for us.
Of course not.
Only
Second and third
factual
category.
problems
Obviously.
which can be addressed by the
Jurisprudential is on this side, but
administrative.
not that side.
There's no delegation of the judicial power of the court.
Yeah, yes. That's all.
Jurisprudential
There can never be, Malhotra, there can never be. A lot of
Singhvi.
shoulders are the strongest. Malhotra. But it may not happen, Malhotra, that the committee doesn't understand what the issue is. Let it be as simple as possible. That's all.
Little legal training.
Dr.
Make
Mr.
it-
Solicitor,
make it very specific.
we've now heard your submissions. We are now almost at the wrap-up point of your submissions. The jurisprudence which we have considered, and your line of submissions, I think there is an area which, even according to your submissions, then that the court can go into, namely to recognize that same-sex couples would have a right to cohabit together, and cohabit together in a normal, peaceable environment in our country without any form of discrimination, either societal or otherwise. Step two, that the government would, as we now see from your very fair suggestion that the Cabinet Secretary, no less than the Cabinet Secretary would be going into it, would be recognizing the incidence of that cohabitational relationship. So we can certainly build upon our jurisprudence as going to that level. Question now is, and we don't want to stop them, whether we make that extra mile, which is what they have argued, and we have also argued that, look, this part would be a legislative exercise, don't step into that. So now what else remains? You can now wrap
Can I
up in 5
conclude
minutes
in
so that we can
15
have
minutes?
someone
Okay, I'll wrap up in 15 minutes, Malhotra. Malhotra, I have filed one note. I'm not going to read it, Malhotra. At the outset, I may put that caveat, Malhotra. But there are only 3 points, Malhotra, which I am making. Malhotra, I'll just give broad propositions and I'll not read it, Malhotra, what is not relevant. Malhotra, my first point, that recognition of marriage is not a fundamental.
There's a note one,
I'm so sorry.
नहीं,
Malhotra.
उसके नीचे है
Note 3, Malhotra.
notes by Mr. Mehta.
उसके बाद नीचे है थोड़ा सा
Yes, so that's this.
So,
last time
Yeah, this was cited last.
the title is closing points.
Closing points.
And my lords, my lord, I am obeying the continuing mandamus, my lord. I am
This one.
using the iPad, my lord.
that's good.
So a weak student, my lord, in at least schools I studied, used to get 5 extra marks for good handwriting. But I need 5 extra marks, my lord, for using this one on the lighter side.